What are the legal bases for product liability claims? First is in contract. For example, claims in contract can generally only be brought against the other party to the contract unless third-party rights have been conferred, which they often aren't. Then there's negligence. Negligence claims don't depend on a contract, but there must be a legal duty of care owed and an identifiable faulty behavior which has caused the loss, and the loss must be of a foreseeable type. And then you have the strict liability regime. The current Product Liability Directive from 1985 is now over 40 years old. That is being repealed and replaced due to a radical reform to the EU's product liability laws and of the existing strict liability no-fault regime. The purported need to update the Product Liability Directive is driven by the concern that the Product Liability Directive was outdated and not fit for the digital world, including with regard to interconnected products, the circular economy, AI, and e-commerce. The strict liability regime is maintained in the new EU Product Liability Directive from the old directive. This was introduced to make it easier for injured individuals to make a claim. Under the PLD, they do not need to prove fault, but only that the product was inadequately safe, in other words, defective. It's important to note that in most cases, the burden of proof lies with the claimant, meaning they must demonstrate that it is more likely than not, in other words, 51 to 49% likelihood, that the defendant is liable for the damages. Now, where are we in terms of the new Product Liability Directive and what's its current status? The new Product Liability Directive went into effect on 9 December 2024. Member states have 24 months from that date to transpose it into law. The new EU PLD will apply to products placed on the market or put into service after 9 December 2026. 27 EU member states and Northern Ireland have to implement the new EU PLD by 9 December 2026. So in short, the new EU PLD has had quite a few changes. This is a quick summary generally on what has changed. The new Product Liability Directive represents quite a shakeup of the previous strict liability no-fault regime. The changes are broad and they affect all product sectors. In order to bring the 1985 Product Liability Directive up to speed with the digital age, circular economy business models, and global value chains, the new Product Liability Directive expanded the scope of potentially liable entities. It expanded the claims that can be brought. It expanded the range of damages that could be recovered and considered to be compensable. And it made it easier for claimants to prove their claims whilst simultaneously front-loaded costs of defendants for potentially unmeritorious claims. The new Product Liability Directive introduced new disclosure requirements to address the potential asymmetry of information available to claimants that can undermine the fair apportionment of risk. It also removed all liability thresholds. Although claimants still have the burden of proof to prove defect, damage suffered, and the causal relationship between the defect and damage, in certain situations, defect and/or causation may be presumed, and the burden shifts to the defendant to rebut any presumptions. Although the new Product Liability Directive exempts manufacturers from liability where the state of scientific and technical knowledge at the time the product was placed on the market or put into service was such that the defect could not be discovered, member states will have the discretion to omit development risk defense exemption when they implement the new PLD. As discussed later in more detail, it also significantly extended the long stop limitation period for claims involving latent injuries. Expanded definitions of the Product Liability Directive. We see an expansion of both the product definition and of damage. Damages claims can be brought under the Product Liability Directive for losses caused by defective products. The definition of product has been expanded in the new Product Liability Directive to include software, digital manufacturing files, and related digital services. Software includes both embedded and standalone software, but not free and open source software developed or supplied outside the course of a commercial activity. Also note that information is not a product, and therefore, product liability rules do not apply to the content of digital files. The new Product Liability Directive seeks to make it easier for a claimant to seek compensation by broadening the scope of physical injury to include medically recognized harm to psychological health, removing the minimum claim threshold of €500 for damage to property, as well as to expanding the scope of damage to include destruction or corruption of data used for non-professional purposes. So on this slide, I have set out the EU Product Liability Directive's economic operators, and I have put in red font those that are new as compared to the 1985 directive. The range of potential defendants against whom claims for damages can be brought in product liability under the new PLD and to who could be held liable has also increased, as noted by those economic operators listed in red. This takes into account the growing significance of products manufactured outside the EU but placed on the single market. The widening of range of economic operators also seeks to ensure that there is always an economic operator in the EU against whom a compensation claim can be made, and it includes those who, quote, substantially modify, close quote, a product outside the original manufacturer's control and also online marketplaces. We have the creation of a new right to claim against a manufacturer's EU authorized representative. This has not existed to date at an EU level unless the authorized representative was the first importer. So this is a significant development as it introduces an entirely new liability exposure for the authorized representative community. The test for defect remains for the claimant to prove a product shall be considered defective where it does not provide the safety that a person is entitled to expect or that is required under union or national law. Now notice that says a person is entitled to expect and not the person. So this is an objective test. And that's actually crucial because at one point when the Commission were considering, when they were drafting various iterations of the PLD, they had at one point considered making it a subjective test, but did go back to the original objective test. In assessing defect, all circumstances shall be taken into account. However, the list of circumstances to take into consideration has increased. The new directive broadens the definition of defect to encompass situations where products do not meet mandatory safety requirements under national law. In addition to labeling, design, instructions for use, assembly, or installation, other circumstances to take into consideration include relevant product safety requirements, including safety-related cybersecurity requirements, any recall of the product, or other relevant intervention relating to product safety by a competent authority or by an economic operator, would now also be taken into consideration, as well as reasonably foreseeable use of the product and the specific needs of the group of users for whose use the product is intended. It's apparent that the new Product Liability Directive takes into greater account the requirements of product safety rules. For example, an intervention by a regulatory authority due to product safety, such as a product recall, would be considered amongst the, quote, circumstances, close quote, to be taken into account when assessing whether the product is defective. This does not necessarily mean that the product would be presumed defective, but it's clearly an important consideration. This also highlights the importance of positive and clear communication with regulatory authorities and robust record management of regulatory compliance actions. The list of, quote, all circumstances, close quote, to be taken into account is therefore clearly wider and more expansive than under the current PLD. So the new PLD's burden of proof and rebuttable presumptions are set out here. The test for defect remains an objective one. Defectiveness should be determined by reference to the safety that the public at large is entitled to expect. However, the new PLD adds a new significant change to the test, adding an alternative basis for a product to be defective where the product does not provide the safety required under EU or national law. However, the new PLD eases the burden of proof with the aim of achieving a more fair balance of industry and consumer interests, particularly in light of the challenges allegedly faced by injured persons in complex cases. The new PLD shifts the burden of proof to favor claimants by introducing rebuttable presumptions regarding defect and or causation between the defective product and the damage that occurred. Defect can be presumed on the basis of non-compliance with the PLD's new disclosure duties, mandatory product safety requirements, or an obvious malfunction. Causation can be presumed if the damage that occurred is of a kind that is typically consistent with the defect. The PLD encourages national courts to apply these presumptions even in the absence of these requirements if the claimant faces, quote, excessive difficulties, close quote, for example, due to technical complexity or scientific complexity, while demonstrating that the product's defect and/or causation is likely. There is no guidance as to what will constitute demonstrating defect, causation, or both, which will no doubt lead to inconsistent handling across member states. Under the new Product Liability Directive, limitation is the same, with the exception of referring to the relevant economic operator instead of producer. A limitation period of 3 years shall apply to proceedings to recover damages under the Product Liability Directive, which begins to run from the day on which the claimant became aware or should reasonably have become aware of the damage, the defect, and the identity of the producer. The injured person is now no longer entitled to compensation. In other words, the claim is extinguished upon the expiry of a period of 10 years, which runs from the date the product was placed in the market or put into service or substantially modified. However, claimants will enjoy an additional 15-year period, in other words, 25 years in total, for latent personal injuries, for example, following ingestion of a defective chemical. Since substantially modified products are essentially new products, the clock will restart after a product has been substantially modified. So, for example, as a result of remanufacturing, a product is modified in such a way that its compliance with the applicable safety requirements may be affected. The Representative Actions Directive, called the RAD, introduced class action mechanisms for each of the EU member states, as well as a cross-border mechanism. When you consider that, in conjunction with the changes to the Product Liability Directive, they together represent a fundamental change to the EU product liability scene. I expect this to, quote, fuel the fire, close quote, and lead to further class action litigation in the EU. So here I've included a table from CMS's European Class Action Report 2024. Although there's a more recent report, I felt that it was helpful to include this slide because you can see in the categories, the product liability, consumer law, and personal injury category was at 32% in 2023. So the data from the 2024 report is the entire calendar year of 2023. And this is really helpful. Although the 2025 report has different data, it has different categories, and so I've just kept the 2023 one, but this can still be helpful even if it's older data, just because it is very clear that product liability is a risk for class action trends. Particularly due to the burden of proof reversal in various circumstances, expect more onerous disclosure to take place during the litigation. I would also anticipate significant front-loading and increase of defense costs. Pre-action early stage disclosure applications are foreseeable. The quality of expert witness evidence is likely to be key. With regard to the burden of proof, greater clarity is needed regarding the evidential threshold for the claimant, as currently, prima facie plausibility appears sufficient. The significance of a breach of product safety legislation, namely a reversal of the burden of proof on defect, may increase attractiveness of injunctive redress actions under the Collective Redress Directive. The supply chain will see a reallocation of risk on account of the broader scope of targets and expanded actionable losses. The new PLD demonstrates the increased importance of technical and scientific due diligence on the product's technical documentation in acquisitions and investments in potential targets. Therefore, this new PLD will usher in a new era in EU consumer protection law. So how do these changes affect companies? You'll see there's the removal of the €500 threshold for property damage, the increased scope of defendants, and the increased form of damages. Those all will lead to a rise in liability insurance costs and insurers' risks. There's also front-loading of disclosure requirements. That in and of itself could lead to increased legal costs for defendants. So then that kind of begs the question, is this going to encourage early settlements? And should it encourage early settlements? There's a consequence, of course, of encouraging unmeritorious claims and encouraging high volume of claims. So that's something definitely to consider. Although it may seem best at the time to limit legal costs by settling early, at the same time, it may have an opposite effect. There's also uncertain liability risks are difficult to insure against. The expected inconsistency of handling across EU member states is another consideration to bear in mind. So liability risks are often about uncertainty, which is difficult to manage and insure against. The risk of inconsistent approaches across member states, in other words, or for example, really, With regard to the scope of disclosure ordered, that could potentially lead to forum shopping across the EU, particularly given the potentially significant expense of the disclosure process. We are seeing a slight variation of transposition approach across the EU member states that could affect the levels of harmonization ultimately achieved. Will there be the opportunity at national level to consider through consultation how the directive fits in with national current laws and procedures? We've only seen a few countries hold consultations, most of which were held after an initial draft was prepared. That said, Hungary, although they held one, held it during summer holidays and for a very short period of time. Despite having no responses received, which could have been interpreted as not allowing enough time for stakeholders to respond, it pressed on faster than any other jurisdiction. Sweden, on the other hand, produced a lengthy investigator's report recommending draft text before holding their consultation that just ended. Will we see some jurisdictions progressing transposition without allowing stakeholders to comment? What about the fact that nearly all of the EU member states are civil law jurisdictions? How will those jurisdictions deal with the burden of proof and disclosure obligations of the new EU PLD? Do they already have procedural rules to deal with this? What about privilege relating to disclosure documents, which those of us in common law jurisdictions know is not necessarily the same as confidential or trade secret? Some countries may frame privilege as we know it in English terms of professional secrecy, like it appears in an English version of the German draft. But whether that term is defined the same as privilege in common law jurisdictions remains to be seen. What choices will jurisdictions make about the development risk defense? How things work in practice may be very different from one country to another, leading to potential hotspots for satellite litigation and/or increase the risk of forum shopping, particularly when combined with increased means of bringing class actions and the availability of third-party litigation funding in some European jurisdictions. Some jurisdictions have already indicated that they will implement the new EU PLD by way of incorporating into a civil or other code, and others as a standalone law. So I have some examples on this slide of both. This shows the different approaches that EU member states are taking. So consequences of failing to implement the Product Liability Directive by 9 December 2026, essentially there's an infringement procedure. The Commission sends a formal notice, then a reasoned opinion, and if non-compliance persists, refers the case to the Court of Justice. Then the Court of Justice can rule the state has failed its obligations, ordering compliance. If the state still does not comply after a first ruling, the Commission can refer it back to the court, which can impose lump sums and daily penalty payments. For failure to transpose directives, the court can impose penalties in the first judgment. France, for example, was 10 years late implementing the 1985 PLD. Hopefully we won't see this delay when the court had to take proceedings against it with regard to the new EU PLD. Now, what about consequences for individuals and businesses? Well, the direct effect is essentially that individuals might be able to rely directly on certain provisions of the unimplemented directive in national courts to challenge the state, as the directive may override national law if the state hasn't properly implemented it. Citizens or businesses suffering loss due to the non-implementation may be able to claim compensation from the state in national courts. So how it works? The process often starts with informal steps, but it escalates formally if unresolved. The Commission monitors implementation and can launch procedures based on its own checks or complaints from citizens and businesses. Thank you for listening. Please get in contact if you have any questions.